A person at the jail, please state your name for the record.
Edmund Arl.
This is case number 26-324-FY, the people of the state of Michigan versus Edmund Roy Arl. Sir, you met with somebody from Community Corrections today and gave them some contact information. Is that information accurate?
Yes.
And did you have the opportunity to meet with somebody from the defender's office today?
Yes.
I have a complaint that alleges that on or about February 1st, 2026 in Greenwood Township of Wexford County, it is alleged in count number 1 that you committed the offense of assault with a dangerous weapon or felonious assault. That is a misdemeanor. I'm sorry, that's a felony punishable by up to 4 years in prison and or a fine of $2,000 and DNA to be taken upon arrest. In count number 2, it's alleged that you committed the offense of assault with a dangerous weapon or felonious assault upon a different person. That is a felony punishable by up to 4 years in prison and or a fine of $2,000 and DNA to be taken upon arrest. In count number 3, it's alleged that you committed the offense of assault with a dangerous weapon or felonious assault on a third person. That is a felony punishable by up to 4 years in prison and or a fine of $2,000 and DNA to be taken upon arrest. Count number 4 is alleged that you committed the offense of weapons felony firearm. That is a felony punishable by 2 years consecutive with and preceding the term of imprisonment for the imposed felony or attempted felony conviction, along with mandatory forfeiture of the weapon. Count number 5, it's alleged that you committed the offense of weapons, firearms, possession under the influence. That is a 93-day misdemeanor and or a fine of $100 to $500, along with mandatory forfeiture of the weapon. In count number 6, it's alleged you committed the offense of weapons, firearms, reckless use. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. Additionally, the court may suspend hunting privileges for up to 3 years. The prosecution also elected to charge you as a habitual fourth offender, meaning that you have at least 3 prior either attempted or completed felonies in your past. That makes each of those 4-year felonies and the 2-year felony punishable by up to 15 years. Do you understand those charges and the potential penalties?
Yes, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request appointed, court appointed.
The court will make a referral to the public defender's office for the appointment of an attorney. Enter a not guilty plea on your behalf. We'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crimes had occurred, and 2, probable cause that you were the person who had committed the offenses. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, in 98, I show a delivery of marijuana. 97, an attempted domestic. 01, a delivery of marijuana. 02, operating while intoxicated. 04, assault and battery. 05, assault and battery. 06, an attempted domestic. In 07, a delivery of marijuana. In 22, an operating while intoxicated. In 23, a fail to stop after a collision. And then in 01, there was a domestic under 4A. The praxis scores him at a risk level 2. Any comment regarding bond, Mr. Harrison?
Well, I'm pleased to note a couple of things. The praxis level 2 is only one of those. The other thing is that the prior felony charges all relate to, as far as I can tell, to controlled substance known as marijuana, which is now legal in the state of Michigan. He is self-employed as a flooring installer. Obviously, this is a slow time of year. I believe any concerns that the court might have with regard to the threat he poses could be easily contained within bond recommendations or bond conditions that are reasonable. I would ask for some kind of nominal cash bond, but I do know that he lacks the resources to even satisfy that requirement at this juncture. So that leaves me with the only other option would be to request a PR bond, despite the nature of the charges.
Thank you. Ms. Dahl?
Your Honor, I believe praxis should be adjusted. He has multiple violent convictions. I believe history of drug abuse should be a yes, considering his multiple OWI convictions and drug offenses. So I believe that would put him at a higher risk level with those changes. The allegations in this case is that he shot at a residence, and specifically the bullets went through a room where 2 children resided. That is, it was by sheer luck. Nobody was hit in this. Had that not happened, this could have been a murder case. So based on those factors, the fact that the victims in this case reside near him, I believe there is a substantial risk to the public. Considering the time that he's facing, the multiple charges, I believe there should be monetary bond in this case, as well as very restrictive conditions. The people are requesting that there be no contact with the victims, that he not enter the premises where the victims reside, that he not possess any weapons or firearms. We are asking that there be daily drug and alcohol testing. He is charged with discharging the firearm multiple times while intoxicated in this case. So we're asking for $100,000 cash surety with also tethering on it.
All right.
Victims residing so closely to the defendant's residence, and the threats that are alleged to have been made, and also the actions that pose extreme risks to the children in the house and the victim. We ask that GPS be included so that way we are further assured that he not contact them or come on their property.
All right, thank you. The court does find the defendant poses as both a flight risk and a threat, more so from the threat standpoint, given that the defendant has an assaultive past, albeit it's been a while. It's, 1, 2, 3, 4, 4 or 5 convictions for assaultive behavior in the defendant's past. The fact that it's alleged that he was under the influence of alcohol, firing a firearm and shooting into the walls of the house. As such, the court is going to, again, find the defendant as a threat. As a condition of bond, Mr. Arl, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm ordering that you not consume any alcohol, and you'll be subject to random testing for that. I'm ordering that you not purchase or possess any firearms or weapons, that you not act in any threatening, intimidating, or harassing behavior. You'll be placed on GPS tether under house arrest with conditions set by community corrections. I'm also ordering that there be no contact provision with the alleged victims in this family, whose initials are MD, AH, and LA. Their names will appear in the pretrial release order. And I'm also ordering that you not have any contact with the residents located on East County Line Road, whose address will appear in the order as well. Given that the nature of the charges, the defendant's past, the court is going to set a $150,000 cash surety bond. Next arraignment. Person at the jail, please state your name for the record.
Christopher Anthony Perkins.
This is case number 25-581FY. The people of the state of Michigan versus Christopher Anthony Perkins. Mr. Perkins, did you have the opportunity to meet with somebody from, excuse me, the public defender's office today?
Yes, sir.
And you also talked with somebody at Community Corrections and gave them some contact information. Is that information accurate?
Yes, sir.
I have a complaint that alleges that between the dates of October 1st of 2020 and December 31st of 22, in count number 1, you are alleged to have committed the offense of child support failing to pay. Those from the dates of October 1st, 2020 through December 31st of 21. That is a felony punishable by up to 4 years in prison and or a fine of $2,000. In count number 2, it's alleged that you committed the offense of child support failing to pay between the dates of January 1st of 22 through December 31st of 22. That again is a felony punishable by up to 4 years in prison and or a fine of $2,000. Do you understand those charges and the potential penalties?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
I request appointment of one.
Right, court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea, and will set the matter for preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor is required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. However, if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show, it looks like in 2010 in California, there was an assault causing injury. In August of last year, there was a hindering apprehension or prosecution. In 07, an operating while visibly impaired. The praxis scores him at a risk level 3. And the outstanding arrearage as of November 1st of 24 was $27,476.13. Any comment regarding bond, Mr. Harris?
Well, the statutory bond will be something in the neighborhood of $5,000. We understand that. That's what he and I discussed earlier. It also my further understanding that he has been extradited here from the state of Texas while he is currently on probation to the state of Texas. And I'm not sure which case it was that you described.
It'd be the hindering apprehension.
It must have been it, yeah, most recent case. So it's somewhat academic. Obviously, if we set up the bond for him to pay the money, I don't know what his obligations are with regard to the extradition component, whether he would be free to leave and return back to Texas or not. So I don't know.
All right. Ms. Dole, I know this is an AG case, but they ask you to weigh in at all today?
I have not heard anything from the AG's office personally, and I have not heard from my staff that we were requested to your office case.
All right. Well, the statute does require that bond be set in at least 25%, which by my calculation is $6,869.03. So the court will set the bond at $6,869 even, and that is a cash bond. I'm sorry, that's cash, not a bond.
Right.
If Mr. Perkins, if you do post bond, you are ordered to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Do you understand that?
Yes, sir.
All right. Thank you. Next arraignment.